It's a little crazy with the kid and the dog.
I can't get my video to work today.
That makes me look adventurous.
Oh, sorry.
Oh.
I know. Oh no.
That was so bad.
Hi, guys. Thank you so much for joining us today. I do think Janine wanted to hop on and say something. So if she comes on at some point, that's totally cool. So thanks again for joining today for our business bankruptcies with Tara. So before we'll get started in just a few minutes, but I wanted to take a look at our code of conduct here. So let me just share something briefly with you all, and we'll go through like some general housekeeping and just things that we've learned so far this week. So let me find that quickly. I hope you've all been enjoying this so far. We've been having a lot of fun. So for our community moderators today are going to be Alex Seymour and Tim Shadone. So they'll be posting a link right now in the chat to our code of conduct, just to ensure we're following community guidelines to make this a safe and inclusive space. So to read that full statement, you can see the link they just posted, and then it'll be in the chat to the right. So if you experience any issues today, you can email us at reporting@nextchapterbk.com. So for some general housekeeping, let's take a moment to just get familiar with the chat, questions, and polling functions for today's session. So as I mentioned, our moderators are Alex and Tim. So if you see anything posted from them, it's going to be relevant information, links into the chat. They'll be answering questions, posting polls. So you can use that chat to communicate with other attendees and inform us of any technical issues. I also have just a few housekeeping notes. So we've had a full house for our previous Bankruptcy Week sessions. So I just want to let you know we're recording every session. We'll post them to our Next Chapter YouTube page later today, and then we'll email you all with the link. So if you're experiencing any connectivity issues, try closing other programs and tabs on your computer, or even leaving the event and coming back in can help. And then Chrome is said to work better than other browsers from the feedback we've been getting. So we've also created a Slack group for you to continue this conversation. It's open to Bankruptcy Week attendees. It's free. We encourage you to join it and network. There are channels broken out by region and already a few hundred people chatting. So we'll include that link in our event recap later today. And then we'll post the link in the chat a few times throughout the session too. So now we can get started. Thank you all again so much for joining us for Business Bankruptcies with Tara Salinas. My name's Katie. I'll be your MC today. And then Tara's going to be going over everything you need to know about business bankruptcies. But first, the stats. So since the pandemic has started, oh, hi, Janine.
Hi, Katie. My computer froze. I wanted to hop on and just chat real quick about a few things before you got started completely. So I'm sorry for just popping in like this.
You're fine.
My whole thing froze and I wasn't able to join as soon as I wanted to. So here I am. But okay, great. Yeah. Hi, everyone. I just wanted to mention a few things before Katie and Tara get started. I know that this is going to be a pretty full session, so I just wanted to mention a couple things since we're kind of halfway through the week. First, when we created the conference, we really wanted to do it so that we could educate everybody about the space, about bankruptcy, and hear from experts on running a successful law firm. And we didn't really include any sessions about our product. That was intentional. It was because we really wanted to make sure that everyone felt, that they were not getting a sales pitch, but rather hearing from experts in the industry. So what we found was as soon as we started this, everybody was like knocking on our door, asking us to hear more about Next Chapter, the product, and to find out how to create a simple case in Next Chapter. So due to popular demand, we did add a session on Friday morning at 9 a.m. It will be myself, Mandy, and then Alex and Tim, who will be joining us to talk about how to use bankruptcy software. And you can sign up for that. You can follow along with us by signing up for free on Next Chapter. And so we will throw the link to register into the chat. And then something else I wanted to mention, I'm not sure if many people know this, but I did just get an email recently about a pro bono case that somebody wanted to do, and they asked about using Next Chapter. And I thought this was something good to point out to a lot of people that, you know, even if you don't do bankruptcies, you may not know, but Next Chapter provides the product for free to anyone who is doing a pro bono case. So for pro bono cases, sign up. All you have to do, anyone can sign up for Next Chapter for free. You can use it all the way up until you file your first case. And then when you go to file your case, you can just go into our chat, let us know the name of the person. We will unlock it for you for free. So something else I just thought about, and I was like, you know, I bet a lot of people would really find this valuable. So okay, a few other things that I wanted to mention before you guys start. I know you talked about the Slack group, so that's great. We have been seeing a lot of networking, connections, mentorship, a lot of different things happening there. So there's over 300 people. Go join it. We're talking about everything. It's broken up into regions, so you can find people in your area to talk about, you know, bankruptcy trustees or what the court likes, or just find somebody, an assistant to help you. Or, you know, I know that a lot of the Slack groups are focused just for attorneys, and we want to not make that the case. This is an inclusive space for paralegals, legal assistants, anybody who's passionate about bankruptcy and law and tech. Join the conversation. Okay, and then the last thing, I'm not sure if this was touched on or not, but Ron Drescher's course on, okay, cool. Ron Drescher's course on Monday was so full that we hit capacity of 1,000. There's a bandwidth issue having more people than 1,000 on this platform. So we know that now for next year. But we tried to find a way to fix that by adding another course for him. So on Thursday evening at 5 p.m. Eastern, Ron is going to be doing an Ask the Expert session. So it's basically a Q&A. He's going to be able to invite some people on stage, ask questions. And so if you want to be a part of that, join that. We'll throw the link in there too. I think that's all I have for now. So thanks so much for participating. And I've been getting a ton of emails about suggestions, encouragement on the event. And guys, this is very exciting and uplifting for us. So thank you so much. The turnout has been just amazing. I want to just keep seeing everyone communicate and growing relationships through the chat and everything. So Katie, thank you. And thanks for being so flexible on me just popping in like this. And Sarah, good luck. Yay. All right.
Okay, so briefly, let me just go over a few things and then we'll get started. So since this pandemic has started, many people are not paying their mortgage. 1 in 4 small businesses have shut down and most Americans in state today. 22 million people have filed unemployment. And so that's why we came up with bankruptcies, because the economy is not going to be the same when we get through this. So as a legal software company in the bankruptcy space, we've seen firsthand the data represented by the ebbs and flows of the economy. During the last recession, bankruptcy
Filings went up 74%.
Sorry, it was me again. Your sound was, it just got like really weird. I think it was because I got out. So, okay, I'm leaving again. Let's make sure it's good.
Okay.
And
is it working? Should I leave and come back?
No, I think it'll work. Let me try to leave and make sure that it's good.
Okay. I'll hop into the chat. Can you all hear me now? Is this working? Okay, cool. We're good. So, This week is it's been all about helping you all learn bankruptcy and how to better your practice. So I would just like to give a quick, brief introduction to our next speaker. Tara Salinas is the founder and managing director of Salinas Law Group, LLC in Denver, Colorado. Her practice focuses on consumer Chapter 7 and Chapter 13 bankruptcy and litigation, as well as student loan law. Tara founded her own firm in 2003 and has handled hundreds of personal and business bankruptcy cases since then. So she's a frequent speaker at local, regional, national, and international bankruptcy programs, including being a contributor to the Central and Eastern European Law Institute's program on international models of insolvency, a practical seminar for Russian practitioners in 2017, 18, and 2020. As a lifelong Colorado native, Tara graduated with a BA from Colorado State University in 1997. After a graduate course in parliamentary government at London School of Economics, she returned to Colorado and received her JD from University of Colorado School of Law in 2001. She enjoys spending time with her husband and her 3 sons and their dogs. So let me welcome Tara to the stage today, and then I will hop off and let her take over. We did run a little bit late on our intros.
Okay.
So, hi, Tara. How are you?
I'm hoping that you can hear me. Good.
I can hear you. I'll check with
can't
everyone
hear
else,
you.
make sure you hear each other. Okay, you're good. All good. So
Yeah, no audio. Let's see
the
here.
chat, and then
Everybody's good. Okay, we're
Yes.
ready to go.
Great. So we went a little over, so I'll be back at like 11:50, and we can do a Q&A.
I can't hear her.
Oh, you can't hear me?
I can't hear Jamie.
Oh, that's okay. It's just me on here right now.
I'll just get going.
Yep, sounds good.
Okay, sounds
Okay,
good.
bye.
Hi, everyone. Thanks so much for being here. I'm really looking forward to talking to you about business bankruptcies. Ron's session on Monday was fantastic. Looking forward to the rest of the speakers as well. I'm going to go ahead and get started with our slides. Please want to let you know that there are some polls that you should check out. I'd love to know kind of what your experience is with bankruptcy so that I can understand how to focus the presentation as we go along. The first is about your level of bankruptcy experience. The second is about what categories of bankruptcy you think we may see need for going forward. Let's see here. All right, so business bankruptcy, what options are available? Obviously, we've been talking about current market conditions. Pre-COVID, 2005 to 2017, about 20% of new small businesses survived more than a year. Of those, 50% survived up to 5 years, 33% for 10 years. Post-COVID-19, recent studies by the U.S. Chamber of Commerce have found that 52% of small businesses are expecting to be out of business in the next 6 months. 33% can expect that they can't continue more than 6 months, and 14% are really uncertain. That's a scary number of people who are worried about not being able to continue. Studies indicate as many as 45% of small businesses were closed, at least temporarily, due to COVID-19. In the hardest hit areas of the country, these numbers are much higher. So Mid-Atlantic region, Pacific region are traditionally small businesses, 55% hit. Even funding that was intended for small businesses, like the PPP program, which we'll talk about later, and the economic injury disaster loans have not been reaching those that are most needed. SBA data, and this isn't just post-COVID, but SBA data is showing that approximately 72% of small businesses are actually sole proprietorships. That means that likely the bulk of the business that we might see in the next 6 months are not organized separate legal entities, but extensions of their owner. Individuals will be responsible for all the assets and debts of the firm. That will impact the bankruptcy advice that we give and the options that are available. we're going to see a huge influx of small business bankruptcies. I keep hearing people say tsunami. I'm not sure it's going to be a tsunami. Usually we see bankruptcies taking from the time people are starting to experience problems. We're looking at 6 months, 8 months, longer, and that could really be problematic. Our caseloads are definitely going to increase. How quickly that's going to be will depend on, where your region is and those kinds of issues. Likely that every practitioner is going to start seeing some bankruptcy questions. It's critical to understand what options are available and know when to say when. I'm seeing that many of you are, new to the practice or are not experienced business bankruptcy attorneys. I think understanding and knowing a little bit about bankruptcy is critical to every bankruptcy practice. You need to know the right questions to ask, but you also need to know what your limitations are. You need to know when you are out of your league and when it's time to get some other help. Quick case filing statistics, U.S. trustee data for the 12 months ending March 31st of 2020. We've had about 764,000 cases filed in the last 12 months. Of those, only 3% of them are business cases. The rest, 97%, are non-business. It doesn't mean there aren't business issues in there. It just means that they are not classified as business cases. Of the cases filed, Chapter 7 represents the vast majority, 479,000. Of those, about 3% are business cases. As you would expect, Chapter 11 cases represent the majority of the business cases, but they're such a tiny minority of the total cases filed. Chapter 13 cases, again, because they're not primarily geared for businesses, although they can be very useful, only represent about 1% of the business cases. Again, the bulk of our caseload is in Chapter 11 are business cases, but they only account for about 1% of the total cases filed in the country. So what's the impact on your practice? As practitioners, it's really likely that you're going to be advising on business issues, but in a consumer case. Much less likely you'll actually be filing a bankruptcy for a business. So today I'm really going to focus on how business and bankruptcy interact, how to spot issues that arise from sole proprietorship, since those are the majority of the businesses in the US right now, and understand the interplay between bankruptcy and business and personal debts in bankruptcy, and how to connect with experienced practitioners for cases that may require a little bit more help. Let's start with Chapter 7. Again, many of you have no bankruptcy experience, so I'm going to go really quickly through the 3 main options that are available here. Chapter 7, you can be an individual or an entity, including corporations, to be eligible for 7. It's a liquidation bankruptcy. We're going to take non-exempt assets, we're going to sell them and use the proceeds to pay creditors in proportion to the amount they're owed and based on the priority system set up in the code. Discharge. The key here in Chapter 7 is that entities, corporations, partnerships do not get a discharge. The only entity eligible for a discharge are people, actual human beings. So if you're not a human, you don't get a discharge. That's going to affect the advice that we give people. Means test is going to determine eligibility for individuals, except there's no means test for people who have 50% or more non-consumer debt. Note, I did not say business debt, but non-consumer debt, and there's a couple of categories there. There's no debt limit in Chapter 7, so you don't have to worry about how much debt the client has. There is no restriction there. Chapter 11, again, individuals and businesses are eligible for Chapter 11. It's a reorganization for the most part. We've got a whole bunch of different options here.
Hopefully this fixes our mic. Better? Yay! We're working on it. Thanks, everybody. I tell you, these electronic presentations are awesome, but we're going to try to make it work. Two different types of Chapter 11, generally speaking. One is a Chapter 11 for non-small business debtor. There are many times when you would choose Chapter 11 for a small business debtor, but we'll go into, I love the chat, but we'll go into that very, very briefly. Second is the small business debtor reorg, SBRA, subchapter 5, subchapter V. You're going to hear lots of different references to small business Chapter 11s. These rules, or this subchapter, just became effective February of 2020. I can't believe how good the timing is on this. However, it's going to be a challenge because there are a lot of untested pieces of the Chapter 11 SBRA subchapter V. These are complex bankruptcy cases. Chapter 11 is not a place to get started unless you have really great mentors, really great guidance. It's a completely different set of procedures, rules. I would encourage only experienced practitioners to be there. And if you are not an experienced practitioner, partner with someone who is, if you're interested in the Chapter 11 process. Finally, Chapter 13, eligibility here is restricted to individuals only. You cannot file a Chapter 13 if you're a commodity or stockbroker. I don't see a whole lot of those cases here in Denver, Colorado, but I know people who live in other areas may certainly see more of that. We're going to see reorganization of debt in a Chapter 13. There are some great options here: strip-offs, cram-downs, bifurcation of claims. Again, those are all available in Chapter 11 as well. The process is just a lot more complex. There is a requirement that you have payments made for between 3 and 5 years, depending on your income. You can always do a Chapter 13 for less time, as long as you pay 100% of the filed claims. The disadvantage to Chapter 13 is that there are debt limits. So secured debt limit is about $1.25 million, and unsecured is just over $400,000. That becomes a really big issue when we have, debtors with a lot of business debt. Say they're sole proprietors with a lot of business debt. Sometimes Chapter 13 reorganization won't work because of that limit. Let's talk about how to spot issues in a business bankruptcy case. The first question that I like to determine is who's seeking bankruptcy protection, especially when you have a small business debtor or an unsophisticated business owner. They're not exactly sure who we are. So I'll have someone come in and they'll say, we really need to file bankruptcy. We're struggling. We can't pay payroll. We. Who's we? Because as lawyers, we understand that the individual may be a separate entity from the business. And so the first, determination for me is, who are the parties here? Who am I actually going to represent? I think it's very well agreed that ethically you can't represent both the corporation and the individual. Now, if it's a sole proprietorship, it's one entity. They're just one big company and person all wrapped up into one. A couple of questions I like to ask anyone who comes in who's currently operating a business is, is the business viable? I've got clients who say, we really want to keep this going. It was really looking great, and now it's kind of struggling because of COVID. Great, but if you have to stay closed for another month or another 2 months, can you recover? Can we catch up on lease obligations? Can we get your payroll back in order? Are you going to be able to get supplies? Do you want to continue running the business? There are many people who feel like they've got to keep going. And offering them the option that they could shut this down, they could shut this down. Could the business be sold? In this environment, maybe not, but there are people who have capital who may be able to invest in these businesses. Could the business be wound down and wrapped up without bankruptcy? That is the number one thing I'm always looking for, because in 99% of the cases, people come in and say, I need to file a bankruptcy for my business. They don't need to file a bankruptcy for their business. We're going to talk about reasons not to file a Chapter 7 for a corporation, but really we like to look at, can we wind this business down outside of the bankruptcy arena? Can we reorganize to help the business become more viable? That's when you're looking at a Chapter 11 situation. Let's talk about I want to talk to every individual who comes in, especially in the gig economy. What's your business income? So, the client works as a regular day job, they're a factory worker, they come in and say, I don't really have any business issues. I just drive for Uber. Well, you certainly do have a business issue. Don't forget about those gig economy jobs. Inquire about business record keeping practices. If you represent any debtors in bankruptcy, especially small business debtors, you'll find that many of them are very unsophisticated in their financial record keeping. Tax filings are not done well, and they may often have tax debt because they don't keep track of any of their tax contributions. They may be behind on payroll taxes. These are things you want to be really mindful of. Were their personal credit cards used to fund the business purchases? Again, many of our small business folks, sole proprietors, even small corporations or LLCs, have used their personal credit to fund the business because they don't have access to business credit. Those count as non-consumer debts. We just have to figure out what they are. Were there assets of the business and where are they? Who has security interests in the assets? 99 times out of 100, if the business has inventory, that inventory is secured by the debt associated with it. Check for UCC filings, be on the lookout for any security interest in those. It can definitely impact the decision to file a Chapter 7 bankruptcy for a corporation or not. Have they pledged personal assets for collateral? We generally see SBA loans secured by residences. Those are often very difficult to deal with. Depending on what's happening with the real estate market, sometimes we can strip those off in a Chapter 13. Sometimes those can be adjusted under Subchapter V. There's some really, really great options there. How's the bankruptcy going to impact the personal finances of the debtor? If their primary occupation thus far has been operating this business, what is their life going to look like going forward? If we shut the business down, if we continue the business, this is particularly important if you've got a sole proprietor who wants to continue their business and we're looking at a Chapter 13 case. Can they actually make the business profitable? If not, the Chapter 13 trustee may insist that you shut that business down. Are the individual's debts more than 50% non-consumer? Take into account taxes that are owed, credit cards, even personal cards that were used to fund business expense, mortgages that may have been used to fund business startup. Those types of debts are often overlooked when we're making that calculation. The reason that's important is you may be able to eliminate a means test in a Chapter 7 case and allow what would otherwise be a high-income debtor to qualify for Chapter 7 protection. Do both the entity and the individual need to file, or can a single case resolve the need? Again, if we're shutting down a corporation, and we don't need a bankruptcy liquidation, oftentimes a bankruptcy for the owner of the business is all that's needed. These are the last two questions that I think are really important. Am I competent to fulfill my ethical obligations to this client? It's exciting when there is a huge flood of cases coming in, especially when you're new to the practice. You have to be careful that you are not overstepping your ability. You have a duty of competence to the client. And as you have an increasingly large number of cases, you may not have the time, energy, or experience to devote to these types of business cases. If you don't, who can you reach out to? You should be making connections through your local regional bar associations. We have a debtors bar association here in Denver. We have a listserv of over 200 people who connect on a regular basis to talk about difficult cases, and that we can then find mentor and mentorships for people who need help. Let's talk about a Chapter 7 for sole proprietor. The majority of cases that are filed are under Chapter 7. Since 72.3% of small businesses are sole proprietors, we're going to see these individuals as our clients. Chapter 7 for an individual who's closing a sole proprietor business is actually pretty straightforward. You're going to list the business as a DBA on the petition. Make sure you list all the assets, both personal and business assets. Do watch exemptions for businesses if the business is closing. So if you've got business assets and you're claiming them, Colorado has an exemption for business property or property used in a business. If you're closing the business, the trustee is likely going to challenge those exemptions. Be sure to list the debt for all the businesses and the personal debt. Even if the debtor is not sure, make sure you're listing it. Disclose all income on Statement of Financial Affairs number 1. Make sure you're disclosing all the transfers on SOFA 7 and 8, and then completing section 18 about business operation. Chapter 7 for individuals who want to continue a sole proprietor business are a little more difficult. Same instructions as the last slide, but you need to make sure that the business interest is either fully exempt, meaning the trustee has no way to take it. 2, there's so little equity in the business that the trustee is going to abandon the estate's interest in that equity. Or 3, the trustee will allow the debtor to buy the business assets back. This can be considerably more complicated and will require some planning. I have had cases where we've planned out a bankruptcy for a year or longer for a sole proprietor who wants to continue a business operation. Maybe we encumber certain business assets so that those can be protected in the bankruptcy. Maybe we slowly collect some accounts receivable that have been outstanding because we don't in Colorado have protection for those. There's lots of different factors that go into it. I know one of the siren songs in this program this week has been talk to us about timing, tell us about timing. There are certainly tips that we can give about timing, and I know Ron's going to address that in his Q&A as well. Timing is one of those things that you start to learn as you practice, and we can certainly give you tips, but again, connect with people who are in your community. Bankruptcy, while it is a national practice and we have a national code and national rules, it can also be individualized based on where you live. So be talking to those people around you to say, hey, I've got this issue. How would you handle this here? Talk to people who are familiar with the trustees you are going to appear in front of so that you can understand what are the things they go after in your particular jurisdiction. Many Chapter 7 clients do have ongoing business entities, and that is their main source of income. These are usually personal service businesses, so the nice thing about that is that the main asset of the business is the personal service of the debtor. It means that they're not easily saleable by the trustee, and they have minimal assets that need to be protected by exemptions. Just a couple tips on those types of cases. Watch for large business losses on tax returns that may be due to exaggerated expenses for legitimate or non-legitimate businesses. We do have some tax preparers who will invent pretend businesses for debtors in an effort to get them larger tax refunds. So be on the lookout when you're seeing tax refunds from any client that have Schedule C income. Make sure that those are legitimate or that you have some support for those. Be real careful in preparing asset schedules, income and expense schedules, and Form 22 means test on double dipping between business and personal expenses. The client may be writing off internet service or mobile phone service or vehicle payments as a business expense. You just need to make sure that it's either deducted from the business income or it's deducted as a personal expense, but not both. When you do have a Chapter 7 debtor who has a separate entity, make sure that you're listing every single debt of both the business and the individual. Even when they don't think they've guaranteed it, I very rarely see individuals who have small businesses who are not personally guaranteeing debts. I don't know many banks, lending institutions, credit card companies, etc., who are giving credit to a business entity only. I generally see that in larger, much larger corporations and businesses. So if you've got a small business debtor, make sure that the debts are listed for both the business and the individual. Chapter 7 for entities. I think there's fairly standard agreement among experienced practitioners that filing a Chapter 7 bankruptcy for an entity is usually frowned on. Why? Wait a minute, this is great. We need to have this. The big reason is they don't get a discharge. So there's not a big benefit to the corporation in filing a Chapter 7 bankruptcy. They don't get a discharge. There are other ways to come to the same resolution without the problems that bankruptcy can bring. The biggest problem I see in doing Chapter 7s for small entities is that the trustee gets to dig into all the financial details of the business. That oftentimes will result in the trustee uncovering fraudulent transfer claims against the owner or insider. Hey, the debtor was paying themselves when they had a duty to pay the creditor. The trustee will then do a clawback for those funds, and the debtor owner will be in a much worse position than had the bankruptcy not happened and you did a wrap up or wind down of the business instead. Assets in a Chapter 7 are going to be quick sold. This is an auction or fire sale environment, so you're not going to always receive top value for assets. It may be better for the debtor to sell those separately. So what are the good reasons to file a Chapter 7 for a business? Yeah, there are a few times where we have done those cases here. One, we've got a store with a whole bunch of inventory. Debtor doesn't want to have to hire an auction house. Debtor perhaps was ill. The owner was ill. And so we had reasons why we didn't want to do that. The owner doesn't have the time or attention to give to a wind down. It's fairly involved. The other is, a business has a judgment creditor. So an unsecured creditor gets a judgment against the business. And the business has significant priority obligations like payroll, tax obligations that we'd like to have paid. If there are enough assets for a judgment creditor to come after the business, sometimes a Chapter 7 would be a good idea to ensure that those priority creditors get paid over the judgment creditor. A couple alternatives to Chapter 7 for entities. I think we've talked about this a little bit. Do an informal liquidation. The owner oversees it. The only downside is the owner also has some liability. So you've got to watch out for that. Sell the business. You do need secured creditors' consent and release, and you got to watch for your Uniform Fraudulent Transfer Act compliance. State court receivership, I generally don't see these unless, a creditor really gets aggressive and steps in. That usually means we're too late. There's not a lot we want to do in those cases. Every once in a while we'll do a Chapter 11 to pull it out of receivership and do some other issues there, but maybe outside the scope of this presentation. So we said Chapter 13 isn't a great option for businesses, but it can be a really good option for sole proprietors. The risk in filing a 13 for a sole proprietor is that the trustees, at least in our area, are increasingly diving deep into the financials of the business. Most of our sole proprietor clients are not sophisticated enough to have the information the trustees are asking for, including complicated financial statements, all kinds of inventory requests, profit and loss statements, information about cash flow. None of our debtors have a 12-month cash flow projection on their gig business. So be careful when you're getting these ready, and be ready to push back against the trustee if they're asking for unreasonable information. The debt limit in 13 can be restrictive, but sole proprietors can reorganize both business and personal debts and can keep business assets regardless of exemption as long as they can pay based on the plan. You can cram down secured debts, and 1304 allows for continued operation of the business as long as it's profitable. If the business is not profitable and requires the debtor's income to be used to service the business, you'll see a push from the trustee to close those businesses down. Chapter 13 for entity owners, be real careful. There is no co-debtor stay for business creditors. If the owner is a guarantee or co-signer of business debts and files a Chapter 13 case, it could result in a default on the business debts and a close down of that credit for the business. It's difficult to address lease arrears in a Chapter 13 case, so be careful on those. And one of the tools we use to do a Chapter 13 for an entity owner is to collapse that business before filing. This is another one of those timing issues that we talked about. We've got to be able to, basically it's a reverse piercing of the corporate veil. You're saying, hey, we've never really maintained The structure of the entity, we haven't been observing those corporate formalities. We're gonna buy out the assets of the business, pay the debts that we can, or assume the debts, and then file a Chapter 13 to address them. This again requires a lot of advanced planning, and it will create timing issues. I mentioned earlier that we've got SIBRA, it's great. We've got an increase in the total non-contingent liquidated secured and unsecured debts. Under the CARES Act, it went up to $7.5 million. That is a very limited time offer. We're hoping that that will be extended more formally by Congress. I'm not going to touch on a whole bunch of SIBRA issues here. There are great webinars that have been going on all over the country. The big players in bankruptcy, National Association of Consumer Bankruptcy Attorneys and the ABI, the American Bankruptcy Institute, have both put on a series of great programs. I know NACPA has a boot camp coming up on SIBRA issues. If you're interested in learning more about Small Business Chapter 11, please watch those programs, get the education there. I can't cover in 2 minutes what you can do with SIBRA, so I'm gonna slide through. Please check the slides, that's no problem at all. I want to touch briefly on some of the things you should be looking for if you're filing business cases. I've got in these slides a long list of documents and information that you should have. Monthly profit and loss statements, annual federal state tax returns for the past 3 years, the quarterly tax filings for the past 4 quarters, all the information about tax obligations, a detailed list of payroll and pension obligations for employees, including their addresses, amounts, how to contact those employees, 12 months of financial account statements, all the creditor statements, insurance documents, real estate documents, vehicle purchase agreements, registrations, insurance. I'm out of breath. You need to be extensive in what you're looking for from either clients who operate their own small business or the business itself. Again, accounts receivable, intangibles, legal actions, perform careful due diligence. I use UCC searches as a way to look for secured debts that clients may not be aware are secured. Dun & Bradstreet has a business credit report that you can use. For sole proprietors, most business guaranteed debts will not show up on their personal credit reports, so be mindful of that. And then we do a judgment search on all of our cases, but specifically on our business cases. Very briefly, let's talk about the 2020 CARES Act. It has had some impact on bankruptcy. It excludes stimulus payments and possibly the supplemental unemployment, $600 a week, monies paid through the PPP and EIDL from inclusion in the means test. Not necessarily an exemption because that got left out on accident, supposedly, but it definitely excludes it from current monthly income. That can be a big deal for a lot of our clients. 1329D was modified to allow Chapter 13 plans to be extended to up to 7 years. That only applies to plans that were confirmed prior to enactment of the legislation, March 27th. It again mentioned earlier increases the debt limit in sub 5 cases from 2.7 million to 7.5 million. So just almost triples the debt limit there. These changes were effective March 27th, sunset on March 26th, 2021. So very limited time. Again, we're hoping that the SIBRA debt limit goes up by formal enactment by Congress, but we'll see what happens. Paycheck Protection Program, of the small businesses that I've talked to who've been trying to get this Paycheck Protection Program, I've seen about 30% that are actually successful. I've got a couple clients who still have applications pending a month and a half later. There's a lot of uncertainty about what will actually be forgiven and the requirements, the hoops that have to be jumped through to get these loans forgiven are pretty extensive. So if you've got clients who are interested in the program, just advise them as to what those requirements are, because I think we're going to see a lot of people who end up with these Paycheck Protection Program loans that they thought they were going to get rid of and they're not actually getting rid of. Last are the economic injury disaster loan. This was touted as like the best thing since sliced bread. It was going to be $10,000 per business, forgivable advance. almost immediately got limited to $1,000 per employee and is now limited to only U.S. agricultural businesses. Again, I'm seeing about a third of my clients who applied for these actually received them, and most of them for significantly less than what they expected. I'm going to go back and let questions come in. I appreciate all of your time today. Thank you so much.
Hi, Tara. Thank you. Can you hear me okay? Can't hear me?
I can hear you now.
Okay, cool. So I'm just waiting quickly from the team. They have a few questions for me. So they went through and collected all of the Q&A, and now we can get started. So one of the questions is, if a small business is owned by husband and wife in a community property state, do both husband and wife need to file for bankruptcy, or can it be restructured so only one has to file?
That's a great question. In a community property state, I don't practice in a community property state, so I'm not going to profess to be an expert there. I'm gonna defer the question just because that's not my area of practice.
Okay, fair enough. Does an IRS lien always trump all other claims, such as a State Department of Taxation lien, for example?
The IRS lien does not necessarily trump everyone. Interesting thing is that in bankruptcy, it's going to be treated equally with the state lien. So priority-wise, the bankruptcy is going to treat all tax liens equally. But if the IRS lien was filed in advance of the state lien, then it should get priority as a secured creditor.
Okay. It appears that traditional first day motions are still required under subchapter 5. Is this correct?
Yes. Subchapter 5, a lot of people were saying, oh, it's like a giant 13. We don't have as small of a debt limit. Subchapter 5 is not a giant 13. Subchapter 5 is a small 11. You're still going to have first day motions. You're still going to have all of the requirements of a chapter.
Oh, wait, you're muted. That's better.
Sorry, you do have some ease in those subchapter V cases, but you're not going to see any real relief from the Chapter 11 procedures and requirements.
Okay. Is there any difference between a strip off and cram down, and what does it mean to cram down secured debts?
There is a difference between strip off and cram down. So a strip off is an absolute removal of the security interest in the property. For example, we do strip offs on mortgages when property values drop. There has to be $0 of equity in the secured property for the debt to be stripped off. A cram down is where there is some secured portion of the debt. We do this often in Chapter 13 in car cases. So the car's worth $10,000, the debt's $5,000. If you meet the other requirements, you get to pay the fair market value of the debt, of the asset, instead of the full amount of the debt. So we cram down the $15,000 loan to $10,000, which is the fair market value of the vehicle.
Okay, thank you.
Of course.
Any sense that these small SBA programs will take the form of direct assistance? From what I gather, these applications are simple. Why does the federal government want banks to administer and take their cut for essentially adding zero value?
Good political question. I don't have an answer to that, but you know what? I don't disagree. I think there's a lot of problems with the PPP program, especially. I think the idea behind it was fantastic. I'm not sure the execution is going to come out the way that they really had hoped.
Okay. I have no idea what I even just asked you, so I'm glad you got it. It's like, am I reading this right? Does Chapter 13 allow petitions by individuals above debt limits if they are 50% or more non-consumer and business debt?
No, there's no provision in Chapter 13 to allow you to file a petition if your debt exceeds the debt limits. I have seen cases filed above the debt limits in Chapter 13. Remember that that's liquidated debts. So sometimes we can deal with that. If you're over the debt limit, but it's not liquidated, you're more than likely going to see issues. We've seen cases where folks try to file because it's student loan debt, so it's not dischargeable. It doesn't usually work. We usually end up seeing those cases dismissed.
Okay. Let's see. Please address the impact of a Chapter 7 discharge on individuals with guarantee of business debt, ownership of business interest, distinction of liquidated versus closed, and existing business interest, and unnamed business client versus creditor.
Whew, that's probably 20 minutes, but
Yeah.
an individual who files and is guaranteed business debt is released from their obligation to continue the guarantee. It's very possible the creditor may come back and call the business debt due or find that it's in default, depending on the terms of the contract, because that guarantee was really critical to the performance of that loan. At the end of the day, it forgives, it discharges the amount due and owing to the business owner, but the business is still on the hook. So I'm going to leave it there.
Okay. Lots of Chapter 7 clients are sole proprietors with failed businesses. What is the tipping point that would make it a business bankruptcy versus a consumer bankruptcy?
If you're a sole proprietor and you have business that has been closed or has failed, usually we're looking at those cases as business cases if it's more than 50% non-consumer debt. That's the determining factor. It doesn't really change much, except that it significantly changes the fact that you don't have to do a means test. So we're really looking at those cases for how much of the business debt is there compared to their personal debt. And remember that if you've got a mortgage, that counts as consumer debt unless it was specifically taken out for the business purpose.
Okay. Oh, it looks like you got disconnected, but I think I can still hear you.
Oh,
yeah,
better?
I hear you. It's just your video.
Sorry.
No, you're fine. So one more question. Can a one-member LLC file Chapter 13?
That would be a situation, yes, you can always file. Whether you can affect the LLC's business debts is another question. It might be a situation where you want to collapse the business before you file if the LLC has significant debts that need to be addressed outside of separate from the personal debt. So we'll oftentimes collapse that LLC, have the owner take on the debts and assets so that they can deal with them in a reorganization in Chapter 13.
Okay, awesome. Well, I think that's it for the questions. We'll have we have your slides people can download. We'll send everyone a recording. Thank you again so much for taking the time today. It was great, and it was nice to see you. It's nice to see new faces.
Always. Thanks so much.
Yeah, awesome. Thank you. And then for everyone else, our next session is at 2 p.m. today, all about virtual paralegals. So feel free to sign up for that, and then we will see everyone later. Bye, Tara.
Bye. Have a great day, everyone.
Thank you.